Collegium headed by you had recommended a member of the ruling party as a judge for the High Court. This person had given hate speeches against Indian Muslims and Indian Christians. You all did not find it necessary or appropriate to withdraw that recommendation.
Your question contains an inference, which is that the Supreme Court didn't look at the issue at all, including after it was drawn to our attention. I don't think that would be a very correct assessment. Justice Krishna, who came out with some of the finest judgments, had a political background. I'm not sure whether we should be cold calling an individual merely for the views which they may have held as lawyers.
Thank you, Chief Justice Chandrachud. My name is Arvind. I'm a student here at the Harvard Law School. I have a question regarding judicial appointments. Earlier in this year, on January 17th, you and the Collegium headed by you had recommended a member of the ruling party as a judge for the High Court. And subsequent media reports came out that this person had given hate speeches against Indian Muslims and Indian Christians. And on the 2nd of February, lawyers wrote to you asking you to withdraw the recommendation. And we know the government was really pacing for her assumption of office. Given the time-sensitive nature of this matter, why wasn't the Collegium headed by you, at least on the administrative side, able to withdraw that recommendation, or at least pending further review? Because the bench that you had constituted in which to look into this case, in paragraph 9 of that judgment, had said that despite the representation given to the Collegium, you all did not find it necessary or appropriate to withdraw that recommendation.
You know, I must say this, that we have been trying to promote transparency in the Collegium. Therefore, you find that all the resolutions which we pass in the Collegium, the Collegium, just to give a broader understanding to people who are not conversant with the Indian system, the Collegium of judges in the High Courts and in the Supreme Court recommend people who will be appointed as judges in the system. The final power of appointment, of course, vests with the President of India. But the Collegium for appointments to the Supreme Court consists of the Chief Justice and the 4 senior-most judges. The Collegiums in the High Court consist of the Chief Justice and the 2 senior-most judges. They make recommendations. Since we are a federal country, those recommendations travel across the system. From the High Courts, they come to the state governments. The state governments will express their view. From the state governments, they come into the union government. They come to the Supreme Court. A thorough check is done on the antecedents and background of the candidate, so on and so forth. So that's broadly, I don't want to get into the nitty-gritty of the Collegium system. That's not the question. But I thought I'll just open it up so that, you know, people who are not conversant with the legal system in India know what the Collegium is all about. Now, I just wanted to answer the question by telling you this, that much though we have been promoting transparency in the Collegium and we put out our resolutions in the public domain, we are equally conscious of the fact, and I think people have to be conscious of the fact, that when we decide on the future of people who are being appointed as judges, we are dealing with the lives of individuals as well. So there is a public interest in understanding what is going on in the system. Why are people appointed? On what yardsticks are people appointed as judges? So we have, for one thing, we have put out the yardsticks on the basis of which we appoint judges into the public realm. And now that's part of, you know, the resolutions which we put out on our website of the Supreme Court. Equally, it's important to understand that the reasons which may lead us to appoint or not appoint a particular judge individually have to deal with the several aspects of the personality of individual judges. And the grave danger is that if we start putting out everything that goes in the process of appointing judges, good people will not accept judgeship. For the simple reason that if you are going to make the scrutiny which goes into appointing people to high judicial office is sometimes extremely trenchant, as it has to be, because we are recruiting people who will be judges for the next 15, 20 years in the system. So the level of scrutiny, including into the personal lives of individuals, which would have a bearing on their discharge of judicial duties, is extremely careful. Now, if we start putting out everything about the lives of individuals into the public realm, there's a grave danger that people would not be willing to accept judicial office. The particular case that your question raised, the reason why I began with this preface was for the reason that your question contains an inference, which is that the Supreme Court didn't look at the issue at all, including after it was drawn to our attention. I don't think that would be a very correct assessment. And to say that, well, we didn't look into the aspect, then again, you have to really ask this. To what extent do you disable an individual from becoming a judge just by virtue of the fact that they have, at a certain point of time, appeared for a political cause? Lawyers, across their careers, appear for a cross-section of clients. Lawyers don't choose their clients. In fact, it's my firm belief that as a lawyer, you're duty-bound to appear for whoever comes to you in search of legal aid, much as a doctor has to administer medical aid to whoever comes to their clinic. You don't presume the guilt or the lack of guilt of people who come to you. So when we look at these kind of cases, I mean, you said that, well, that particular person was a member of a political party. We looked at it very, very carefully. The nature of the speech which that judge is alleged to have made at a particular point of time, again, is looked at very carefully. One of the processes which we follow in the Collegium is to ask for a report from the Chief Justice. If we are in doubt as the Collegium, we go back to the Chief Justice of the High Court and we say, well, this has been drawn to our notice. Would you please give us a brief report on whether this is true or false? We ask for a feedback. We share that feedback with the government. The process of appointing judges is therefore a fairly complicated process involving different layers of the federal system, the states, the union, the governments in the states, the government in the Union of India, investigative agencies such as the Intelligence Bureau, which do a background check on the antecedents of an individual. So this is a very broad-based collaborative process which is going on, where no one arm of the state has a decisive role to play. And just to give you one example, one of our greatest judges, Justice Krishna Iyer, who came out with some of the finest judgments, had a political background. My own experience has been that judges who have appeared for a cross-section of diverse political views across the spectrum have turned out to be amazing judges. So I'm not sure whether we should be cold calling an individual merely for the views which they may have held as lawyers, because I do believe that there is something in our profession of judging that once you assume judicial office, whether it's peer training, the training which you undergo as judges, your experience as judges, there's something about this office which makes you dispassionate, or which at least ought to make you dispassionate in terms of your the work which you do, your interface with colleagues, your interface with the bar. And particularly in a society like ours, which is an open society, wedded to democratic ideals, the bar and the pressure of public opinion, the press, the media, these are very important counterweights which ensure that judges are true to the oath and perform in accordance with the Constitution. Because every part of the work which we do as judges is being constantly evaluated and reevaluated by civil society, by the media. And I think that's an important aspect of ensuring that judges work in terms of their constitutional mandate.